Thanks everybody for joining us today. Just our standard disclaimer, this presentation is for educational purposes only. It's not legal advice and it doesn't create an attorney-client relationship for anyone who's not a client. Also, this is kind of a complex issue. There's unfortunately not a bright lines. It's more of a case-by-case basis as we'll get into. So today we're basically providing an overview. If you're already a client and you have a question, you can send it through our portal. If you're not a client and you're interested in getting help from us on a specific legal issue, we'll have some information at the end on how you can sign up. And with our topic today of navigating the ADA and the interactive process, we want to start with an overview of the ADA. It's always a good place to lay a foundation down, just kind of get everybody's mind in the right spot, and then kind of fill out the information as we go through it. So this is a topic that we have spoken on before and we will speak on again. This is an area where we get questions from clients, if not daily, for sure weekly. We're getting more than one ADA related question a week from our clients. So it's something to be very aware of as an employer, as somebody in management at a company. This is something that you want to stay on top of. And there are a lot of potential pitfalls, unfortunately, with this type of issue that you've got to be aware of so that you can avoid having problems in your organization. So with an overview, the term ADA applies or refers, to the Americans with Disabilities Act, so ADA. And it's a federal law from 1990, and it applies to employers with 15 or more employees. We'll talk a little bit more about the employee numbers shortly, but that's just kind of a starting point. Also in play when you're talking about the ADA is the ADA Amendments Act, or the ADA AA. That is a newer federal law from 2008 that basically expanded the regular ADA. Under the ADA AA, a definition of disability is going to be construed in favor of broad coverage, and it's not going to demand an extensive analysis. So in other words, the ADA was passed in 1990, the ADAAA was passed in 2008, and with that newer law, they wanted to really expand what was covered. It's easier, in other words, to meet the definition of disability under the ADAAA. Also, don't forget state laws. State laws also apply to disability, they apply to accommodation, and they apply to the interactive process as well. As one example, the Minnesota Human Rights Act, which covers, parts of it covers similar issues to the ADA, that applies to employers with 1 or more employees. Again, the federal ADA is 15 or more employees, but depending on which state you're located in, there could be a much lower threshold to look at disability, accommodation, and interactive process issues under state law. So keep that in mind depending on where you're located. So really part of the overview is the ADA requires employers to refrain from discriminating against qualified individuals because of a disability. It also requires employers to provide a reasonable accommodation to individuals with a disability. And a reasonable accommodation is a change in the workplace, or application process that makes it possible for an individual with a disability to either perform their job or apply for a job. As we talk today, we'll use the term ADA to incorporate also the ADAAA and equivalent state laws throughout the presentation. Sometimes that just makes it simpler. There aren't, again, always bright line rules under this law or this series of laws. So it's very much a case-by-case issue, as we noted earlier. And you want to be careful with this type of law, because if you make a misstep, there can be steep penalties under federal or potentially both federal and state law. So just something to keep in mind. And after the overview, we want to get into some of the definitions that are key when you're looking at an ADA issue. So the first one is covered employer. So that's a private employer with 15 or more employees on its payroll during 20 or more calendar work weeks in the current or preceding calendar year. Again, that's under the federal ADA. There could be different requirements under state law, but we're just going to keep it on the federal with this definition. A qualified individual means a person who possesses skills, experience, education, and other job-related requirements necessary for the position. They also must be able to perform the essential functions of the position with or without a reasonable accommodation. Some additional definitions: disability. That's a physical or mental impairment that substantially limits one or more major life activities of an individual. So think of things like walking, standing, talking, hearing, being able to perform work, being able to drive, etc. A disability can also include a record of that type of impairment, or if someone is regarded as having such an impairment, that's also covered under the definition of disability. Reasonable accommodation in this context means a change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. The parentheses on that, again, absent undue hardship to the employer. So we're going to talk about reasonable accommodation in more detail, and we'll also talk about undue hardship as well. And then interactive process means a collaborative discussion between an employer and an applicant or employee to determine if a reasonable accommodation can be made for a disability or impairment that limits a person's ability to perform their job or to be hired in the case of an applicant. So keep these definitions in mind as we go through the rest of our discussion today. A major part of looking at the ADA and the interactive process is considering reasonable accommodation. In the on the employer side context of this, what you really want to have as a best practice is a reasonable accommodation policy. If you have a policy in place, it's in writing, it's going to demonstrate your commitment to ADA compliance. It's useful for an employer to have a written reasonable accommodation policy. It will be called upon as an exhibit if your company's ever facing a disability related claim, whether it's from a federal or state agency or from an individual applicant or employee or former employee as a plaintiff coming after your company. Your written reasonable accommodation policy is going to be an important exhibit for you, and it provides you with an argument that the company was aware of and made employees aware of the company's approach to handling ADA matters. So that's why that policy is important. It also informs employees who are requesting a reasonable accommodation for a disability. It tells them what to do if they think they need an accommodation. That's another reason to have a policy. And you also want to make sure that with your written policy, you get it out to your employees. It's got to be distributed to everybody. You should also obtain a signed acknowledgement of receipt of the policy. And your policy, as a side note, can be included in an employee handbook. That's something that we commonly do with our clients, or it could be used or distributed as a standalone. But in either case, you want to make sure that you get a signed acknowledgement from each employee that they've received the policy. Part of our discussion is looking at the interactive process. We are again speaking about the ADA, disability accommodation and interactive process stuff. So we want to get into the interactive process piece of it now. So say you've got this scenario within your business. An employee has requested an ADA reasonable accommodation. They've come to you and said, hey, having some issues getting my work done due to a medical concern. They're requesting an accommodation. Or as an employer, maybe you're aware that an employee is struggling potentially due to a medical issue, and that a reasonable accommodation under the ADA may be needed. If you're in either of those scenarios where, number one, somebody has asked you for a reasonable accommodation to be able to do their job, or two, you observe where somebody is struggling with their job and it could be based on a medical reason, then you've got a responsibility under the ADA to start the interactive process. One of the things you want to do with this, though, is you want to check for ADA coverage. Let's talk about that a little bit. So is the person a current employee? Are they an applicant? If the person is an employee or they're an applicant, remember that the ADA applies to both applicants and employees. Is somebody a qualified individual? Remember, that's a definition that we discussed just a few minutes ago. That's an individual with or without reasonable accommodation can perform the essential functions of the position, either that they currently hold or they would like to hold. and the person also has to have the skill, experience, education, physical, medical, safety, and other requirements needed for the job. That's plays into when you're looking at the interactive process. Is the person a qualified individual? Additionally, does the person have a disability? Again, a disability is a physical or mental impairment that substantially limits one or more of the major life activities of an individual, or they have a record of that type of impairment. So that's one of the things that you're going to consider with starting the interactive process. But another point to think about with this is direct threat. It's not on the slide, but it's something that is covered under the ADA law. Somebody might not be a qualified individual with a disability who is required to be accommodated if they pose a direct threat. Now, this doesn't happen all the time, but it's something to be aware of with your analysis when you're looking at somebody who may need some help. So a direct threat is basically a significant risk to the health or safety of others that can't be eliminated by reasonable accommodation. When you look at the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm may occur, and the imminence of potential harm. A person who is a direct threat may not need to be accommodated. Maybe in a real world example of direct threat where somebody wouldn't be required to be accommodated would be thinking of something like a heavy equipment operator who has a profound seizure disorder. If somebody is prone to seizures frequently, and their essential job is to operate a piece of heavy equipment around other workers, that's a case where direct threat could come into play, where somebody may not need to be accommodated. But again, this is something to look at on a case-by-case basis, but I just wanted to put that out there for people to consider. So is the interactive process triggered in your situation? Did the employee request an accommodation? One of the scenarios we just talked about. Did the person provide you with sufficient information that they need some help? They might say something like, I have a disability that affects my ability to walk, and I need to discuss what we can do within my job to see if I can be accommodated. That would be an area where you'd want to start the interactive process. Keep in mind, however, as an employer, that an individual doesn't need to mention the ADA specifically or use the phrase reasonable accommodation to make a valid request for an accommodation. However, the employee, when they're speaking with you, does have to clarify that they need an adjustment, change, or other assistance at work, and that the need is related to a disability. Although a request for reasonable accommodation from an employee doesn't need to be in writing under the ADA, it's always a good idea to document the request either in a letter, a memo, or an email that you as the employer, after you have a conversation, you deliver it back to the employee. You say, hey, here's a quick summary of what we discussed. That gives you a paper trail that you are taking the steps as required under law. And also that record can then be placed in the employee's confidential medical file as evidence that you had spoken with them. They discussed maybe something that needs an accommodation related to a medical issue under the ADA. That summary email, memo, or note that you generate, that helps protect your company to show, hey, look, we had this conversation, we took this first step. And again, that's going to be placed in a confidential medical file. That is not going to be placed in a general personnel file. The other thing that you want to consider is the disability or need for accommodation known by you as the employer? Sometimes employees are going to self-report a disability and ask for reasonable accommodation, but there could also be circumstances where the interactive process may be triggered even when the employee has not requested an accommodation. As we just kind of mentioned, an employer should consider initiating the interactive process without being asked only if the employer knows somebody has a disability, reasonably believes the employee is experiencing workplace problems because of a disability. Again, if you see somebody struggling at work, performing a task that looks like it could be medical related, that could cause you to have to initiate the interactive process. Or if an employer reasonably believes the disability prevents the employee from requesting a reasonable accommodation. So a couple of different ways that this can get going are somebody asks for an accommodation, or you see that somebody might be struggling medically to be able to do their job. Under that circumstance, you as an employer should start the interactive process. Now, keep this in mind too. If an individual with a disability states that they do not need a reasonable accommodation, then you would not proceed with the interactive process, but you for sure would want to document that discussion. When you're engaging in the interactive process, there's kind of three main steps. You want to communicate with the employee. You want to explore the possible accommodations. You want to select an accommodation. We're going to talk about each one of these in turn. Communicating with the employee, this is going to be critical. As an employer, you should always respond promptly to a request for reasonable accommodation and engage in the interactive process in good faith. After somebody says, hey, I think I need some help in my job, I've got a medical issue, you want to, as an employer, engage in an informal process as quickly as possible just to clarify what the individual needs and try to identify the appropriate reasonable accommodation. Also, you want to be sure within your company that you're communicating directly with the employee as part of the interactive process. The employer should not just internally talk to the employee's supervisor, their manager, or the human resources department, and the employee is excluded from those discussions. No, instead, you want a company representative speaking directly to the employee when you're communicating about the interactive process. It has to be a two-way street, so make sure you keep the employee involved. As you're talking to the employee, ask them relevant questions so that you as an employer can make an informed decision about any request for reasonable accommodation. You could ask about the nature of the disability and the precise job-related limitations that they're experiencing because of their disability, the problems or workplace barriers in place because of the disability, the type of accommodation they're requesting, and what their qualifications are. Now, if somebody's need for accommodation is not obvious, in other words, it's not something that you can see directly, maybe consider asking for reasonable medical records about the individual's disability and functional limitations to, in fact, verify that they do have a covered disability that needs a reasonable accommodation. If you've got a non-obvious situation with an employee, so it could be maybe somebody struggling with a mental health issue, you can do the following. You can require that the records come from an appropriate healthcare professional. You can ask the employee to sign a limited release, allowing you as the employer to submit a list of specific questions to the healthcare provider, or you could use an interactive process questionnaire, which is a document that we provide to our clients regularly. And you can discuss with the employee the nature of the employee's disability and functional limitations. When you're having these discussions, make it clear to the individual why you are requesting this information. You want to verify the existence of an ADA disability and the need for reasonable accommodation. If you're starting this process, the disability is not obvious, you're asking for information. If the individual turns around and provides you with some documentation that is not sufficient to cover what you asked for initially, you can explain why the records are insufficient, meaning they don't say he has a disability or they don't explain the need for reasonable accommodation. And then you would allow the individual to provide the missing information in a timely manner. You can potentially have an individual go to a healthcare provider of your choice as an employer to substantiate the disability and the need for your accommodation, but you can only require that they see a specific healthcare provider under very limited circumstances. That is that the individual has provided insufficient information from their own doctor. If the individual fails to provide any missing information in a timely manner after being given an explanation and then time to get you the sufficient information, the medical information or examination that you require is job related and consistent with business necessity and is limited to determining the existence of a disability and the functional limitations that require reasonable accommodation. And finally, you can require them to see someone of your choosing if you pay all costs associated with the examination. Now, as an employer, you should not ask for records from an employee if both the disability and the need for reasonable accommodation are obvious. It's something you can see, you know they have this disability, or if the individual has already provided you with sufficient information to substantiate that they have an ADA disability and that they need reasonable accommodation. Do not ask an employee for records that are unrelated to determining the existence of a disability and the need for accommodation, such as a person's complete medical records. You can't ask for that under the ADA. Instead, you've got to focus on their ADA disability that is limiting them at work. And you can't ask for information relating to another disability or medical condition that the person might have. You've got to focus on the specific disability that's limiting them in their job. The next step you want to look at with the interactive process is exploring possible reasonable accommodations. Identify a potential reasonable accommodation that may help them overcome the limitation in their job resulting from their disability. That's going to be one of your main steps. Remember again that this has to be done in consultation with the employee. It can't be done solely behind the scenes between, say, the owner of the company and management, or the owner of the company and human resources. No, the employee or applicant themselves has to communicate directly with the company. Again, you want to think about reasonable accommodation and what is required. That means modification or adjustments to, say, for example, with an applicant, the applicant process that would allow them to get through and apply to your job, or looking at the work environment where somebody performs their job. You want to consider the range of possible reasonable accommodations that may be required, again, absent undue hardship to your business. And so some of those range of accommodations could include making your existing facilities accessible, some job restructuring, part-time or modified work schedules, reassignment to a vacant position that is equivalent in pay and status if the person is qualified for that position. You want to look at acquisition or modification of equipment and devices, appropriate adjustment or modification of examinations given to people for qualifications, training materials, policies. You can look at providing qualified readers or interpreters in some cases, permitting use of paid leave if someone needs some time off related to a disability, providing unpaid leave, modifying a workplace policy, including those relating to no-fault attendance, things along those lines, altering supervisory methods and communication styles, providing equal access to information, and providing opportunities for those with disabilities to participate in employer-sponsored training. There are cases sometimes when an accommodation would not be considered reasonable, and we want to talk about those as well. So an accommodation that would not be considered reasonable and therefore would not need to be provided would be changing a primary job responsibility or elimination of an essential function, not a secondary responsibility, not a secondary essential function, but a primary job responsibility or an essential function. You don't have to remove those. You do not have to lower production standards. You don't have to provide paid leave beyond that, which you provide to similarly situated employees. You don't have to provide personal items for use that could be used on and off the job, such as a prosthetic limb, a wheelchair, eyeglasses, hearing aids, or similar devices. That's not considered a reasonable accommodation. You do not have to excuse a violation of a uniformly applied conduct rule that is job related and consistent with business necessity. For example, conduct rules related to violence, stealing, or destruction of property. Accommodation does not have to be made that allows those. You do not have to remove other employees from their position to accommodate a disabled worker or create a new position. You do not have to automatically promote a disabled employee. You do not have to help an employee become qualified for a vacant position. You do not have to reassign an employee in a way that violates your seniority system unless your system includes special circumstances or exceptions. And you do not have to excuse past misconduct before the employee requested an accommodation. You can ask the employee for suggestions to assist in determining the type of reasonable accommodation to provide. However, remember that the employee is not required to specify the precise accommodation needed. You can notify the employee of any vacant position for which the individual may be eligible as a reassignment. Again, you don't have to create a position, you don't have to bump somebody else from their job, but if there is a vacant position for which they are qualified, reassignment into that vacant position could be a valid, reasonable accommodation. You can assess whether the proposed accommodation may pose an undue hardship. We'll talk more about that in a minute. And you can choose to provide an accommodation beyond what the ADA requires. In other words, as an employer, you can choose to go above and beyond what the ADA requires, but you are not mandated to do so. After you've explored possible accommodations, you want to select an accommodation. Some steps with that are you want to assess whether the proposed accommodation is reasonable by evaluating whether it seems feasible or reasonable on its face, whether it enables the individual to perform the essential functions of the job, and whether it allows the individual to enjoy the benefits and privileges of employment that employees without disabilities enjoy. Understand that the employer does not have to provide the exact accommodation the employee or job applicant wants all the time. Your provision of an accommodation just has to be reasonable. That is the operative term. It doesn't necessarily mean the specific thing the person requests. If it's not exactly what the person requests, you're okay as an employer if you choose the accommodation that's effective in removing the workplace barrier at issue. And if you offer alternative suggestions and discuss those with the employee, it doesn't, again, have to be specifically what they ask for. What you provide as an employer has to remove the workplace barrier and be reasonable. If more than one accommodation is available, know as an employer that it's permissible for you to choose the accommodation, as long as it's effective, that is less expensive or burdensome, is easier to provide, or requires the employee to remain on the job instead of providing unpaid leave. So you do have some wiggle room as an employer to not necessarily, again, provide the exact thing they ask for. For example, say an employee asks for leave as a reasonable accommodation for a disability, to attend medical treatments, recover from an illness, receive training, make repairs on equipment or device. In those cases, leave may be viewed as a reasonable accommodation versus maybe a different type of accommodation that they may ask for that is outside the scope of what is required under the law. It doesn't hurt, however, to give consideration to what an employee would like as their preferred accommodation, but you can, again, as we've discussed, you do have some leeway within providing an accommodation as long as it's reasonable or removes the barrier. You want to make sure that you act promptly to provide the reasonable accommodation. Don't wait around, and understand that the interactive process for this particular disability is going to end once the accommodation is selected. But there could still be ongoing discussions if there needs to be further changes to the employee's work situation based on their disability. That's just something to keep in mind, that you provide the accommodation, but after a while, if the accommodation is not effective for some reason, then you may have to reopen the interactive process for that issue. Be sure to document all communications with the employee and attempts at accommodation. Keep a solid paper trail. That's always going to help you if some sort of claim is brought by the employee down the road, or if a federal or state agency is investigating you based on maybe a disability issue. Having that paper trail of, this is what we talked about, this is when we talked about it, this is the accommodation that we attempted to provide. That type of information is going to help you in the long run and could actually end up preventing you from being liable. We mentioned undue hardship before, but we want to speak about it now in a little more depth. A reasonable accommodation discussed during the interactive process does not need to be provided to the employee if it would create an undue hardship to you, the employer. If you think that something that someone is asking for as a reasonable accommodation would be an undue hardship, then you've got to really take some steps and evaluate it. An undue hardship for an employer exists if the accommodation is too difficult, too expensive to provide in light of the employer's size, your financial resources, and the needs of the business. Looking at factors such as the nature and cost of the accommodation, the overall financial resources of the company, the number of people employed at the facility, the effect on expenses, resources, or other operations of the place, the overall financial resources, size, the number of employees, and type of location, type and facilities locations of the employer, and any impact the accommodation on the facility's operations, including the ability of other employees to perform their duties and the facility's ability to conduct business. So, generally speaking, you've got to have the discussion, look at potential reasonable accommodations, but you are not required in every single case to provide a reasonable accommodation if you're getting into these areas of undue hardship. Again, when you look at the company's size, your financial resources, and some of the specific factors we just mentioned. If you're looking at expense or difficulty creating an undue hardship and using that as a reason to potentially deny a reasonable accommodation request, understand that that expense or difficulty has to be significant in order to be able to claim undue hardship as an employer. It can't be a small amount of money. It can't be a low level of difficulty. It's got to be significant under the law. And if you're looking at cost as a potential argument to use for undue hardship, that would stop you from providing a reasonable accommodation. You still have to look at whether funding is available from an outside source, such as a state rehabilitation agency, that could help you overcome that hurdle. You also have to look at whether you have eligibility for certain tax credits or deductions to offset the cost of the accommodation. So if you're looking at cost, you have to look at potentially alternative sources of funding to help you lower that cost before you can purely claim cost as an undue hardship, thus denying reasonable accommodation for an employer. And you could also potentially ask the person with a disability to absorb some of the cost, but this again goes into the case-by-case analysis of every situation that we spoke about at the beginning of the discussion today. You've got to look at all these different factors individually each time with an employee. You cannot, as an employer, claim undue hardship based on fears or prejudices of coworkers of the person or customers, or potential negative impact on morale. Those are not valid reasons to claim undue hardship in order to deny a reasonable accommodation to someone. A lot of times undue hardship could be in play if, however, there are things like a huge disruption to other employees' ability to perform their jobs. That's something that you've got to look at. If somebody who is asking for leave as a reasonable accommodation, if they say they can't provide a fixed return date, and you as a company are not able to cover the cost of a replacement, that potentially could be something where undue hardship could be used to deny a reasonable accommodation. Again, open-ended leave may not be a reasonable accommodation. Focus on each individual situation with reasonable accommodation, with the interactive process, and then also, as we're talking about here, with undue hardship. A blanket one-size-fits-all approach won't work. It's got to be case by case. Be sure as an employer that you're maintaining records of your interactive process efforts. You want to document every step of the interactive process from the initial request through the accommodation selection and then implementation of that reasonable accommodation, or if there's a denial of the request for an accommodation, you've got to have documentation of all those conversations with the employee, who was involved, when the conversations took place, what was discussed. Have documentation of that. Also, to protect your business, document any failure of the employee to engage in the interactive process. For example, if they don't respond to your communications or requests for information, say you need more information to verify the existence of a disability and what modifications may be needed in their job. If you've asked them to provide that information and they're not providing it, you've got to note that. You could have emails, you could have records of phone calls, you could have records of things that you sent to the employee, either say by US mail with return receipt requested, or through a courier service with receipt and delivery signature. You want to have documentation of all of your communications with an employee on this subject and your attempts at communication. That's also important. We touched on this earlier, but it's worth saying again, you want to keep employee medical information confidential. With the interactive process, with going through reasonable accommodation process, with discussing disability, that's all medical related and it all has to be kept confidential. You should maintain medical information received during the reasonable accommodation process in a confidential medical file. That's going to be separate from an employee's regular personnel file. You should have a separate medical file. Do not disclose to other employees that an individual is receiving as an accommodation, as this may create liability for you because you are then potentially revealing that the employee has a disability. So don't tell other employees the person is receiving a reasonable accommodation. An employer can respond to questions from coworkers if somebody says, hey, what's going on with Steve? How come his job changed? You can emphasize that you have a policy of assisting employees who have difficulties in the workplace. You can point out that issues encountered by employees in the workplace are confidential, and you as an employer respect the confidentiality and privacy and don't disclose information about specific employees. Ahead of time, a way to head some of this stuff off is to either through a standalone written policy or in an employee handbook, you can provide all employees with information about the ADA, about reasonable accommodation, about leave laws such as the FMLA, or if your state has a paid family leave law, if your state has a paid sick leave law. That tells employees, generally speaking, that under certain circumstances, people may be gone from work or people may receive assistance in their jobs. That's a way to kind of do it on a blanket basis. When you're informing your supervisors and managers about restrictions on the employee's duties and necessary adjustments to their job, do not disclose the disability to the supervisors and do not disclose confidential medical information. You can just simply state that the person has restrictions in their job or the person is receiving this accommodation in their job. Don't disclose the disability and don't talk about confidential medical information. You also don't want to coerce an employee into disclosing their disability or accommodation to coworkers. An employee can voluntarily choose if somebody asks them to say something, but generally, again, other coworkers should not be pushing employees for medical information from someone else, but an employee who's receiving an accommodation or has a disability may just on their own freely choose to offer information to other employees or coworkers saying, hey, you know, I've got something wrong, so that's why I have this different workstation, but that shouldn't be something that comes from you as the employer. You can't provide that information. You want to look at other federal employment laws when you are considering ADA, reasonable accommodation, the interactive process. You want to also look at other laws that where there can be an overlap, where more than one law could be in play that you as the employer are responsible for following when an employee or an applicant is in one of these situations. So with employees, there's the Federal Family and Medical Leave Act, FMLA. That can provide protections to employees that are ADA related. So if you're covered by the FMLA, that means you're an employer with 50 or more employees within a 75-mile radius. Somebody could receive leave under the ADA as a reasonable accommodation, but that could overlap into FMLA, which provides unpaid medical leave that's job protected for an employee's own serious health condition. You don't have to, under the FMLA, under the ADA, provide an employee with time off to care for, say, an employee's family member that has a disability. The ADA does not require you to accommodate an employee working with a disabled family member, but if they're covered by the FMLA, that employee who says, hey, I need time off to care for a disabled family member, that might be allowable if your company is covered under FMLA and if the employee is eligible to take FMLA. The ADA and FMLA also have requirements relating to leave and modified work schedules. There could be intermittent leave under the ADA or a single block of leave. FMLA leave is also job protected. There are different areas where the ADA and the FMLA could overlap. That's just something to be aware of if your company is covered by the FMLA. We mentioned this earlier, but when you're looking at disability, when you're looking at the interactive process, when you're looking at reasonable accommodation with an employee, the federal ADA is in play if you've got 15 or more employees. However, state and local laws are going to be potentially in play as well. A lot of times state laws are more employee friendly than, say, a federal law. Again, as we talked about earlier, the federal ADA, 15 or more employees makes an employer covered. Under some certain state laws, it could be only one employee and you're covered under a state version of the ADA with similar requirements. The definition of disability could also be more lenient under state law. What qualifies as a reasonable accommodation could also be different under state law than what the federal ADA requires. And when you're looking at these situations, you definitely want to start with the federal ADA if you've got a disability, reasonable accommodation, or interactive process situation in your work. But you want to expand your thinking to also consider, are there applicable state laws I need to be aware of that might even be more employee friendly than the federal law that I'm working with? If you're in a location where a state or local law is more protective to an employee than the federal law, that more protective state or local law would apply. The law that is most favorable to an employee, if there's a difference under federal law and state law, is going to be the one that's applied. That's just how things work. So keep that in mind as an employer. Another important factor to consider when you're dealing with the ADA, reasonable accommodation, the interactive process, is that you don't want to discriminate or retaliate against employees who are making themselves available for this process or seeking the protection of these laws. Employees have rights under the ADA. They have a right to reasonable accommodation, and they can legally exercise their rights to a reasonable accommodation, again, under federal law. As an employer, you've got to be very careful to not retaliate against an employee for engaging in the interactive process. Prohibited retaliation under the ADA could include things like continuing to ask an individual to provide more information when you already have sufficient information to go through the interactive process, look at reasonable accommodation. If you just keep asking and asking and asking, that could be considered retaliation. Or insisting that an employee continue to be examined by different healthcare providers, that could also be a potential retaliation situation. If you have granted an employee leave as a reasonable accommodation under the ADA, you cannot then penalize them for work missed when that leave, when they were gone, was again given as a reasonable accommodation. That's also going to be impermissible retaliation under the ADA. That would basically mean that you've provided an accommodation, but then you're taking it away because you don't think it's working. That's going to be considered failing to provide a reasonable accommodation. Generally speaking, don't discriminate against disabled employees. An example of that would be if you're denying a request for leave to the disabled person, but you allow the request for leave for similarly situated individuals who do not have a disability. If you're singling out your disabled employment for worse treatment than other employees in the same job, that's going to lead to a discrimination claim. All of your employees have to be treated consistently. You want to also make sure that you treat all employees consistently within the interactive process, not just with the accommodation itself, but also in the interactive process. If you don't do that, again, you're looking at claims for discrimination and retaliation, which you do not want under the ADA or any equivalent law. So we've talked about quite a bit of information today. You might be thinking, well, how can you help me with my business to get through some of these issues? Well, ask us. I mean, we're very well versed with the ADA, the interactive process, and reasonable accommodation. Again, this is a common area of questions for us. If we don't get questions daily, we definitely get them weekly. So we are familiar with navigating through these waters. If you're not subscribing to our weekly newsletter, I would recommend doing that. Comes out every Tuesday. We've got information in there on rule changes, new laws, and we do discuss laws relating to disability accommodation, the ADA interactive process. If you are one of our clients, we can also advise you on the best way to handle some of these tricky accommodation situations. Again, we're experienced, we're familiar with this. This is something that we do definitely see. I think Dan has some information here.
Yeah, thanks, Michael. That was some great information. Thank you all for attending today. If you have any questions about the material covered, whether it's just the ADA, the law itself, the interactive process, or reasonable accommodations, we ask that our clients open up a ticket directly in our portal. This way we can help you with a specific legally backed answer for your specific situation. If you're not a client of ours and would like more information about how we can help you with the ADA, please email us at info@myHRcounsel.com. We'd be happy to schedule a demo for you or provide some information about how we can help you with our great options for you. We hope to see you again on another webinar in the future, and I hope you all have a great rest of your day. Thank you.
Thanks, everyone.